Welcome to Looking at Legal Stuff. Today we have two hearings in a case with a couple where Dad is objecting to Mom's motion for a relocation that he claims Mom hasn't done properly. Because even though the court has not yet heard her motion, she's actually moved out of state already, and she only gave him a week's notice that she and his son would be going. He claims that not only is the school and community in their new location not as good as the ones the child is in now, but he also feels this move was not motivated by a better life for their son, as she claims, but that her real reason for wanting to move to this town is to live with her new boyfriend of 4 months, who's moving there to start a legal cannabis business. He says his son has already had to change high schools 4 times due to other moves caused by Mom's unstable housing and relationships, and a fifth move would not benefit him. Dad also claims that he and Mom were co-parenting just fine up until recently, when he informed her that he'd be marrying his girlfriend, who just happens to be Mom's sister. What does Mom have to say about this move? Let's find out.
Here. So I've got Woodley and Alston. I think I saw Mr. Alston on the screen. Good morning.
Yes, I'm here.
And Aaron Winkle's appearing on behalf of Mr. Alston.
Okay, and we have Jessica Woodley. There we go. I have her current in the courtroom. So this again, this isn't normally my docket, so I was reading through this case, trying to determine where we were at.
And we were trying to determine the same thing, Your Honor. It looks like 3 separate, well, 2 petitions were filed, child support modification, and then a move without the normal amount of time. And then it appears Mom gave 1 week's notice. The 20 days hadn't told for many of the petitions. So we attempted to answer everything, but there was no docket. There was just this set. And this was just set on, I believe, the child support. So we're not sure where we're at. We filed our own motion to hear all of those issues on the represented docket, but we're not sure if Mom wants to have everything heard then. There is the issue of apparently Mom's already moved, which is a problem. We don't know where to go because we're not sure what Mom's intention was with this hearing today. And we're not sure my client even got served everything. I did see what was on Odyssey, was able to print it off and answer it. But that's kind of where we are. So we answered everything.
So I'm looking at, you noted this on for the 17th, which was yesterday.
Um,
Oh, wait a minute.
no, we noted it on for
the response date was the 17th. I'm sorry.
Yeah.
Okay, so this is set for October 1st. So when I looked at this, I started to see there was some issues about service because I looked at the declaration of service. So I'm not 100% sure what we have, what this is actually noted on for today here.
And that's our problem as well, because the certificate of service just was very general, but there were all these petitions filed, which we didn't even know about until I went back in to check the time of today. And then we saw that there were other petitions that had been filed. So we did answer those again, but that's why we set it on the represented docket to give Mrs. time to essentially respond back. There is a service issue with that as well, because it appears Mrs. has moved. So we're not sure kind of what to do. So we'd ask the court to give us instruction. If she's here today, maybe she can assist with that as well.
Ma'am, what can you help give us some guidance here as to what you're?
I put a PO box to serve, and I have an email to be served. I haven't gotten anything back from them. So.
Okay, I'm showing you at the Ridgefield address is what you've got for service on your paperwork. Is that still?
No, I do not live at that residence.
Okay, so we need, from the court, we need to have a current address. So there's a way to get documents to you, because that's where we're going to send them unless we have other information. We do have your Gmail address. Are you agreeable to email service? Okay, so we can do that. So that's on the docket notice, Ms. Winkles. I don't know if you. So at least
Yeah,
at this point, that's probably workable. My concern was, and this was based on, the reason why I didn't know what we were doing today is what I've got is a notice of hearing for today. And it talks about relocation and modified child support, but I don't have any, the affidavit of service that was filed, which was the one filed, looks like Mariah Peterson. And it doesn't tell me exactly, it doesn't, there's a number of things that are filed. I don't know which ones were actually served.
What are you asking? I'm sorry.
Well, and your process server needs to file an amendment to this to say what documents were specifically served. This talks, you've got two petitions. I don't know which one was served. You've got two summonses. I don't know which one was served. It's not attached here. So there's procedural. I don't know that I can go ahead today.
Okay.
They've noted this on for October 1st, which is 2 weeks. And you've not received those documents. Okay.
And I can reset that to the week after to give her the adequate notice to essentially file a response, or if she wants to file any other documents, or if her documents are okay. I have no problem doing that.
Okay, it looks like, I'm just looking at your certificates of service. Those were all sent to this Ridgefield address. So I think maybe at this point, if you can resend those to her Gmail address, which is listed on her notice of hearing.
Yep.
And then we can leave it on the 1st, and we probably need to leave it
Okay.
on the 1st so it doesn't kick out too far, and then we can determine if we need more time at that point.
That sounds good. That's what we'll do.
So you're gonna get a bunch of documents in the mail. I need to have your process server do an amended declaration of what was served that lists everything. Maybe if that's all that was served, I mean, it's not clear because there's two petitions and it doesn't say which one was served. So that needs to be filed. And a copy of that should go to Ms. Winkle's office. And then we'll come back on October 1st. That very well may end up getting set out a week for timelines unless everybody's agreeable to go forward at that point. Okay.
Okay. Thank you, Your Honor.
All right. So strike today. We'll set everything over to the hearing on the 1st. And Ms. Winkles, you'll get those documents that I assume today.
Yes, we will.
Okay. So you should have those documents in your email address.
Thank you.
Okay.
All right. Thank you, Your Honor.
Welcome.
Thank you.
All right, again, number 1 on the docket, 15-3-00468-3, Alston v. Alston.
Yes, Your Honor, that matter's kind of ready. In that, we originally filed this, it was originally heard on the 18th. It was moved to allow us to serve. We served that same day. Mother was there on the 18th. It was moved to this date. On Friday at 11:40, my client was served. My office was not served. I'm highly doubtful that the state has been served, even though they are a party. They really waited to the last moment. It looks like from the court filing, it was also filed on Friday. I would still like to move forward because we've attempted to serve, and you'll notice from our certificate of service that mom's already moved. So because of that, I'd like to go forward today.
And I'm assuming you are?
Jessica Woodley.
Okay, so she is here in the courtroom. So we have Ms. Winkles online. Do we have the state?
Yes, Your Honor.
Okay. All right, so with that, I should go ahead and hear from you first.
Okay.
I'm going to have you go ahead and take a seat and just be right in front of that microphone and speak up as make sure we get everything recorded. Okay, go ahead.
Good morning, Your Honor. I'd like to apologize in advance. I'm really nervous.
It's okay.
Good Good morning, Your Honor. I am the mother of 4 children, Mariah, Michelle, Liam, Alston, and Maxine. At present, Mariah has not yet graduated from high school. After careful consideration, I firmly believe that relocating from the city to a more rural environment is the best interest of my children, particularly Liam, who has been facing significant challenges in his current school setting. I've been offered a position at Asante Hospital in Grants Pass, Oregon, which will provide me with stable employment and the opportunity to further my education. I've also been accepted into Rogue River Community College, where I am guaranteed a spot in the nursing program due to fewer applicants. If you could please refer to Exhibit A and Exhibit B. Additionally, I have secured a housing voucher for Josephine County, which will facilitate the move should it be granted. The decision to relocate is largely driven by my concern for Liam's well-being. He currently attends Richfield School in Richfield, Washington, where he is struggling socially, academically, physically, and emotionally. He has been the victim of persistent bullying and frequently returns home in tears. His experiences at school have deeply affected him, and it is increasingly difficult to send him to an environment where he feels unaccepted, unheard, and unseen. The rural community in Oregon offers a safer environment, smaller class sizes, approximately 19 students per teacher, and more individualized attention for Liam, which I believe is critical to his success. His 504 plan will transfer seamlessly to Oregon, ensuring that his educational needs will continue to be met. Please refer to Exhibit C. I am confident that this fresh start, combined with smaller class sizes and a supportive environment, will significantly improve Liam's well-being and overall quality of life. Contrary to statements made by Mr. Alston in his declaration, pages 2 and 3, Liam does not spend 45% or 48.4% of his time with him. Liam has always resided with me and his siblings, attending school in Richfield Monday through Friday. Mr. Alston's role has been limited to every other weekend visitation. He has not attended any of Liam's medical appointments, as evidenced by documentation provided in Exhibit D. Furthermore, Mr. Alston has not been involved in any of Liam's school activities, as shown in Exhibit E. On page 4 of Mr. Alston's declaration, he references a CPS report, lines 16 through 21, in an attempt to discredit my parenting. However, Exhibit F demonstrates that these claims are false. I am asking the court to allow Liam to relocate with me and his siblings, who he has never lived apart from. Should the court determine that relocation is not in Liam's best interest, I'm fully committed to remaining in Washington with him. I am not seeking to alter the custody arrangement or interfere with the relationship between Liam and his father. Mr. Alston's involvement as an every other weekend parent would remain unchanged. I firmly believe that this move is in Liam's best interest. However, if the courts find otherwise, I will prioritize my son's well-being by remaining in Washington.
Thank you. Ms. Winkles?
Yes, Your Honor. First off, mom has already moved. You can see from the certificate of service that was filed that there is no furniture in that house. There are no people. Mom has moved. And in fact, the notification of move was given 1 week before the intended move. And you'll notice that as
I
well.
object to that, Your Honor. I have not completely fully removed. I have resided.
No, hold on.
Okay.
So your objections are legal objections if
Okay.
you're going to make them, but you'll have another chance to respond.
Okay.
Okay, go ahead, Ms. Winkles.
Yes. So mom essentially bypassed the statute. Now, what caused this? Well, mom and dad were co-parenting, and while mom is the primary parent on paper, dad essentially had 48% of the visitation. He had almost the entire summer. He had almost every single weekend. Dad was active in all of the extracurricular activities of the child and was present for almost every single game. The child does have ADHD. Dad was not present for any of those meetings because mom has moved the child 4 times over the course of the last few years, oftentimes not notifying the court, oftentimes not notifying dad. This makes it very difficult for dad to actually get in touch with the school because mom continually moves the child. This is due to mom's unstable housing and also unstable relationships. Mom is not being essentially genuine when she's talking about why she wants to move. The reason for the move is because mom has a 4-month relationship, and that person is attempting to move to Southern Oregon, Northern California, in order to enter the cannabis industry down there. This was a spur of the moment decision. Mom only let dad know a week ahead of time after dad had just gotten married. I think it's really important to look at the background of these two parties. Both of them had significant drug and alcohol issues. Both of them had criminal issues. Both of them got clean. My client has done very well for himself. He got clean. He opened his own business. He bought his own house. He got married. He had other children. Mom has struggled a little bit more. Mom has several children from other relationships that she has sole custody of. One of those actually wrote a declaration in this case, Mariah, who's just turned, I believe, 18, suddenly writes a declaration about my client handing people marijuana. Well, my client doesn't do drugs. My client has been great at maintaining his lifestyle. He is not following anybody in the cannabis industry. He's not handing 13-year-olds joints. I think you can see from the exhibits that have been delivered to your honor, some of them are more concerning than others. We have a CPS result from CPS from 2013. Clearly, they both identified that, they both dealt with the issues there, and they moved on from that. My client has other children. There are no CPS findings. There are no CPS considerations. There's nothing of that sort. We then have an email that is a little strange in the amount that's deleted from it and the highlights and the lowlights of the toner. It makes it look a bit strange, a bit faulty, a bit fake, to be honest. Then we have the mom stating things as, I got into this university. Well, mom didn't get in because it's open enrollment essentially, and your honor, my client has submitted those things. Anybody can get into this. It's a community college, much like LCC. If you apply, you get in. Mom then says, I have this job as a CNA. Mom had a job as a CNA here. Mom was working in Vancouver, was making very good money. Child was going to school in Ridgefield, was on a program due to ADHD. There is absolutely nothing in the record, minus mom's self-serving declaration that said, not even in a declaration, that says that the child was bullied, that the child was struggling, anything like that. What is true is that mom has removed this child from different schools 4 times in the last few years, causing the child to have to start over in an educational program over and over and over again. This lack of stability is causing the child's educational deficit. This is clear that when a child has to start somewhere else new every single time, they have to essentially learn everything those children know in that school to catch up. And then they have to go forward from there. Unfortunately, Liam is never able to do this because Liam keeps getting moved. As we all know, Ridgefield is one of the best schools in the entire state. It has one of the highest literacy rates. It has some of the lowest class sizes of all of Washington. It scores 91%. According to all graduation rates in the state median. Then we look at where the child's been placed, Grants Pass. Grants Pass has an incredibly low literacy rate. Grants Pass has high issues with crime. In fact, Grants Pass has 86% more crime than the rest of the state of Oregon. Most likely, this is because it is a high cultivation area of the cannabis industry. It's right there in that whole green zone. And likely there's probably a lot of crime in that. There is nothing in this move, and that's what we really have to look at. We look at the factors of, will this benefit mom? Will this benefit the child? If we look at these factors, there's absolutely no way it will benefit either of them. Number one, all of mom's family lives in Cowlitz County or Clark County. All of dad's family lives in Cowlitz County or Clark County. The child's support, stability, the child knows all of his family, knows his extended relations, knows his cousins, spends time with all of them. They're all here. Everybody that provides this child stability is located in this community. There's been no agreements of the parties. Mom came out of this out of left field, essentially 1 week before it happened. The fact is dad was becoming very, very central in this child's life. Has been for the last few years. Dad has taken a much more central role. And this is where we get the 48%. While mom may be on paper as having primary custody. The fact is this child was with my client the entire summer. Are there residential limitations for either of them? They both have substance use problems on their findings. They both have CPS reports on their findings. Nothing recent. Good faith. Is this good faith? Absolutely, it is not good faith. Dad tells mom he's getting married. Then suddenly mom says, well, I'm moving. I want a big life event as well. So mom is moving, chasing after a boyfriend of 4 months in the cannabis industry, uproots her family with no place to live. She gets a housing voucher from Josephine County. I think that says it all. She gets a voucher. She doesn't have a place to live yet. Getting the voucher from Section 8 does not mean you're finding a landlord that accepts Section 8. Those things are very, very different. Mom has absolutely no place to live. At the moment, mom has moved everybody into the house of a friend. That means all 4 of her kids, mom and the boyfriend, all living in the house of a friend, essentially living in the living room. This is not assisting and not being desirable for Liam's stability. Again, she's already moved 4 times. Without following any of the court's recommendations, the child keeps getting uprooted. Different schools, different extracurricular activities. Nothing about this is helpful to the child or mom. Mom's not making any more money. Mom is not going to go to this fancy school that she can't get here. Same idea. LCC offers the same program. And more importantly, LCC is in state, which means mom is a Washington resident. Why she's choosing to go to a community college out of state that's going to cost her significantly more is anybody's guess. If we look at the quality of life and the resources, again, everybody is in this area. This is a rural area, but it also has access to things that a child with ADHD needs, such as doctors. It also has behavioral therapists, occupational therapists, things of that nature. Whereas Grants Pass, frankly, doesn't have access to nearly the same amount of support and the same amount of educational opportunities. The other thing is the financial instability. Right now, mom is moving to an area where there's nobody to be there. They're living in a living room. In this area, she's got her family and friends to do babysitting. She can borrow money from family and friends when things get tight. The financial instability of having Section 8 vouchers, possibly having a job, the same amount that she was earning before. All of this is not in Liam's best interest. We're hoping. It's essentially them playing the lottery in hopes that they're going to kind of strike it rich, or, we're going to hit gold. But that is not what you do to an 11-year-old child. The fact is that this child needs what dad has been providing, which is stability. Mom moved without the court's approval. She's not in a program that would stop her from being able to change. If Your Honor stated today that Your Honor was denying the move, mom would come right back to where she was, probably into the same house. Child would probably go right back into school, only having missed a couple of weeks at Ridgefield. They'd probably go right back into their family. Mom would go right back into her job. Nothing would change. If Your Honor approves this move, she's essentially cut my client off. She's made it so nobody is watching this child in school. She's put them in a crime area that's 86% worse. And frankly, allowing mom to chase a guy who's been engaged 3 times in the last 24 months, and to going and finding his marijuana dreams. So, Your Honor, we'd ask that you deny the move, that you force mom to move back. If mom doesn't want to change the parenting plan, that's fair enough. But that mom comes back to this county, and next time she moves, that Your Honor puts her on notice that she has to do the notification procedure correctly.
Hold on. Looney, anything you wanted to add?
No, Your Honor.
All right. This is your time for rebuttal.
Your Honor, I feel I have provided evidence to show you that Mr. Olson is being untrue in his signed declaration and has had the same ability to provide you with the same evidence, but has chose not to try to deceive you and to try to paint me as a bad parent. When in fact, I have been our son's primary parent his entire life. Mr. Olson has also moved 3 times in the last 7 years. As the economy goes up and down, individuals have to move, showing that Mr. Olson has had to move as well. My CNA license shows why it got pulled in the CPS case. However, I was able to get it back and I can continue my education now. The drug use I would like to address, it is in the current parent plan. If Mr. Olson was concerned, then why hasn't he given me a UA? Same for me, I have no concerns as him using any illegal drugs or substances. Richfield School, if your honor grants the move to Grants Pass, Oregon, Liam won't attend Richfield, nor if Liam moved to his dad's, he would not attend Richfield schools because his dad nor his wife, also my biological sister, would transport our son to Richfield. Mr. Olson is asking for Liam to reside in Longview with him, but also attend school in a different county. As far as Mr. Olson's and my sister's marriage, they have been together for 11 years. I've been well aware of their wedding. I even helped plan their wedding with my sister. As far as my significant other and I, we have been together for over a year. He has no criminal background. If the courts would like a background check, I would be happy to provide one. If Mr. Olson was concerned about my significant other, he should have expressed it to myself, or my sister, his wife, could have expressed it to myself as well. We were close until I disclosed my plans on relocating. I would also like to reiterate to your honor that should the court determine that the relocation is not in Liam's best interest, I'm fully committed to remaining in Washington with Liam. I am not seeking to alter the custody arrangement.
So I did review the files and record, and based on that, the court does find there is a substantial change of circumstances by the statements as a whole. And that's done in reference to what Ms. Winkles has said in regard to her client, as well as what's been said by the mother. As I said, the change is one brought on by either the mother's move to Oregon or by the alleged statements of the father. He has the child a substantial amount of time. As to whether or not it is in the child's best interest to make the move is unclear, in part because there is not complete information from the mother without, the declarations were not objected to. So the court is going to deny the move at this time. It was not done appropriately. So the mother, if she chooses to move back, needs to move back within 2 weeks. Okay.
Does that need to be-
My question to you is, if you do that, are you going to proceed forward on this action?
Probably not. Probably just keep the parenting plan as the same as it was before, if Mr. Alston agrees to that.
Okay. So with that, I'm denying the move. I am denying the movement forward on this, and so the matter is denied.
Thank you. And do your honor want me to get an order to you?
Yes, make sure to send it to mom and let her review. So basically she'll put an order together, send it to you. If you agree it reflects what I ruled,
Okay.
then you can sign off on it. If you don't, then it can be set before me and we can go through it.
Okay, do I need to reside in Clark County where I was, or is?
You need to be in the
towns?
same school district as you were, and if
Okay.
you move, you gotta go even from where you're at now. You need to go through the appropriate process to, so you're not in the same kind of situation again. Okay? All right.
Thank you.
Thank you, your honor.
They had a presentation of order hearing for the signing of the denial order by the judge on November 1st, which was after they returned to in-person hearings, so I don't have it. I'm sure that Attorney Winkles did a good job in preparing the order, so I don't know how much Mom may have bothered to quibble about the details. She did say she wasn't trying to change anything to do with Dad's custody time, so I'll give her the benefit of the doubt that the hearing was quick and easy. It sounds like this family has overcome a lot of obstacles, but this move wasn't the best thing for their son right now. I hope Mom remembers to complete the paperwork before the move next time if she doesn't want to end up in trouble with the judge or end up with another denial. See you next time.